It was a misuse of market power. Last Friday, by agreement with the Australian Competition and Consumer Commission, the publicly listed Cabcharge Australia declared to the Federal Court that it had breached the Trade Practices Act. Penalty, including costs for 3 conceded breaches, $15 million, said by the ACCC to be the highest penalty yet imposed for such breaches. It was a plea bargain to a string of anti-competitive, predatory and other charges brought against Cabcharge, which, with its affiliated networks, dominates the taxi industry in New South Wales and Australia. Cabcharge has boasted to investors that its ability to make money rivals the Australian mining industry's biggest players. But aren't taxis meant to be a complementary public transport service regulated by government? This week, Cabcharge senior executives, including Executive Chairman Reg Kermode, have been blasted by ACCC Chairman Graham Samuel. There's been no contrition and a bad attitude towards compliance, he says.
They have an attitude problem, because if they were going to put out a statement that essentially manipulated the numbers and attempted to portray it as a Cabcharge win, then they just don't get what occurred.
What has led Graham Samuel, the chairman of the Australian Competition and Consumer Commission, to publicly attack Cabcharge executives, including Chairman Reg Kermode? It was this statement issued last Friday by Cabcharge Company Secretary Sharon Doyle. Cabcharge's share price jumped when investors realised that publicly listed company's protracted legal dispute with the ACCC was over, settled through an agreed penalty of $15 million, including $9 million and $2 million for Cabcharge's refusal to deal with competing suppliers of FPOS services, and $3 million for anti-competitive practices in the supply of taxi meters and fare schedule updates. But in its own statement on the court settlement, Cabcharge delivered what to Graham Samuel was this backhander.
Cabcharge is pleased that the ACCC's long-running investigation and proceeding have today been finalised. Cabcharge has admitted certain facts only for the purpose of the ACCC proceeding and consented to the 3 declarations of contravention of the Trade Practices Act, civil penalties and compliance orders made in the ACCC proceeding by Justice Finkelstein in the Federal Court in Melbourne today. Cabcharge denies, and the ACCC is not pursuing any of the other 8 allegations of contravention made by the ACCC in the proceeding.
As a result of that statement, I felt obliged to go out into the public arena and to say there was an attitude problem. And the attitude problem is that, I think, clearly of Sharon Doyle and of Reg Kermode in the company itself. But more importantly, there is a board of directors here, independent directors, and some very significant people are on that board. And they must understand that Cabcharge has crossed the line in terms of the Trade Practices Act. It is now in the centre of the radar screen of the ACCC. We'll be watching everything they do to ensure they do not misuse their market power in the future, that they do not engage in predatory pricing. And I think it's incumbent on that board of directors to impose the corporate governance disciplines that boards should impose on the senior executives of the company to ensure that attitude problem is corrected.
The Cabcharge board comprises directors with interests in the biggest taxi networks operating in Australia and includes the former Premier of New South Wales, Neville Wran. Executive Chairman is Reg Kermode, known as Mr 10% to disgruntled taxi drivers across the country because of the surcharge Cabcharge applies to FPOS payments. Reg Kermode is an Australian business success story. He founded Cabcharge in 1976.
Evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Mr Kermode was a reluctant witness at the recent Upper House inquiry into the industry. Watching the dispute between Cabcharge and the Competition Commission was Sydney University economist Dr Peter Abelson.
Clearly the ACCC is taking this very seriously. However, the action only hits part of the real problem. The action so far largely involves other companies which want to use their electronic processing system and was simply life was made difficult because Cabcharge tried to stop them using the Cabcharge card. But of course in Sydney 60% of the cabs are still run by Cabcharge themselves through CCN Communications, and that doesn't really get at the use of the monopoly charge for their cabs.
Your complaint is that we don't have genuine competition because of market dominance.
Yes, that's the real problem.
Dr Abelson says that while $15 million does sound like a substantial penalty, this highly profitable company probably would not miss it. We put this scepticism to the ACCC chairman.
If you take $15 million and relate it to its annual profit of $60 million, it's a very significant penalty indeed. But we have to remember that some of this conduct related to what was pre-January 2007 conduct, where there was a different penalty regime in place. Now, Parliament introduced into the Trade Practices Act a new penalty regime. We can now obtain, for breaches of the competition provisions of the Trade Practices Act, maximum penalties that can equate to 3 times the gain from the anti-competitive conduct, or if that can't be assessed, 10% of the annual turnover of the company. Now, we didn't work towards assessing the gain. It would have been very difficult to do it in this case, so what we went for was the 10% of turnover.
Taxi customers paying Reg Kermode's 10% for use of their credit cards on Cabcharge's system should know that the ACCC dispute did not tackle this issue. But, however, Graham Samuel says a new compliance regime coming as a direct result of the case would allow other FPOS providers into the system. Charges for FPOS services over time should be competitively reduced. The recent Upper House inquiry into the taxi industry has recommended sweeping regulatory reform to help break Cabcharge's dominance. The inquiry put great weight on the evidence and submissions from Dr Abelson.
There is this regulation which says you must be able to service all parts of Sydney sort of 24 hours a day, 7 days a week, which establishes a monopoly.
Do we have what has been called in other industries here regulatory capture? That means that the people who are meant to be regulated have in fact captured the regulator, and the regulations are designed to service and look after the vested interests.
Yeah, I think we do have a form of regulatory capture. I think what has happened is that the Ministry of Transport has found it very useful to have taxi drivers supervised by the networks. And that absolves them from the problem of monitoring and supervising the taxi drivers. In return for this kind of responsibility to monitor the taxi drivers, the networks have claimed all kinds of powers over the taxi drivers. Really what's required is an independent taxi regulator.
Les Wallinga, now the Director-General of Transport, has told Stateline he's established an independent Bureau of Transport Statistics to help reform the industry, and is now working through the Upper House inquiry's list of reform recommendations. The Bureau is also researching claims that fees, charges and surcharges make taxi services in Greater Sydney among the most expensive in the world. Over to you, Mr Regulator. Stateline again sought an interview with Reg Kermode. He declined. Stateline asked if Mr Kermode would respond to our email questions. He declined.